Your Lordship, we must to file written notes of argument. I am filing, my Lord. I will serve the copy to the other side.
My lord,
Grateful.
my lord, day before yesterday on 4th, matter was taken a my matter, where my lord job chart of the my lord petitioner, my lord is asked.
Not job chart, note.
Note. Now they are saying the note.
Note.
What has happened? Your Lordship was at the time of dictation. Your Lordship was pleased to fix the matter on 11th February. But I got the order copy. It is fixed on 11th.
11th February, I will not.
My lord, date of retirement of the petitioner on 28th February.
So
11th February it was fixed.
to be mentioned. 11th February.
28 is the date of retirement. That's why.
My lord, may I permit to mention the matter?
To mention it on 11th. You please inform.
Yes. I shall give notice.
Your Lordship,
My
may I
lord,
permit to mention one matter for restoration, Your Lordship.
Restoration.
My lord, may I permit to mention a matter for restoration?
For the petition.
After hearing the parties and on perusal of the materials on record, this court finds both the trial court and the appellate court have erred in convicting the petitioner under section 323 of the IPC. Therefore, both the decisions of the trial court and the appellate court deserve to be set aside. Accordingly, CRR 539 of 2017 is thus allowed. Connected application, if any, are also thus disposed of.
Grateful, my lord.
The judgment dated 15/12/2016, passed by the learned additional session judge, Fast Track Second Court, Sialda, South 24 Pargana, and judgment dated 17 May 2016, passed by the learned judicial magistrate, Sixth Court, Sialda, South 24 Pargana, are hereby set aside. Present petitioners, namely Prashanto Pakre and Prashanto Pakres alias Sibu, is acquitted of the offence as alleged, and he is released from his bail bond.
Grateful. Grateful.
Trial court record, if any, are be returned to the
Deeply obliged.
Milord, my restoration application, Milord, I have served, Milord, your lordship, on 26th August 2025, Milord, dismissed the matter, Milord, for default. Milord, on that day, Milord, I failed to appear before your lordship, Milord.
What is the matter about?
Milord, the Electricity Act, your lordship heard this matter, asked me to file an affidavit including all documents. Milord, I prepared the affidavit. Milord, thereafter, the matter, Milord, on two occasions, the matter did not reach, Milord, On 26th August, my lord, I was not, my lord, due to my absence, my lord, my apology, my
Within
lord,
time,
my,
within time.
within time.
Service contract.
Affidavit of service. Sir. My lord, this is the affidavit of service, my lord. Nah, private electricity board part.
Affidavit of service.
Right, item number 4, I'm for the petitioner.
This is also restoration.
No, my lord, this is a recall of the final order and judgment dated 16th of July 2025. Your lordship would remember, lordship was pleased to quash 3 of them, 498A, allegation of 498 along with 3 and 4 of the Dowry Prohibition Act. So the father-in-law, mother-in-law, and the sister of the husband, they were quashed. However, my lord was not pleased to
Husband.
quash the allegation against the husband. Now that's why I have annexed some other documents and slightly on a different footings, but I will try my
How I
luck.
can review this application? Is there any error in my judgment?
No, my lord, just on some particular factual aspects, your lordship.
What factual aspects? Where is the observation made by me that there is a case against the husband?
My lord, if your lordship kindly comes to Annexure A and Annexure B, Annexure B once, page number 20.
No, come to the operative portion of the judgment where I have dealt with the allegation of the husband.
Yes, your lordship.
Where is the mistake? Where is the error
My lord,
apparent on the
Paragraph
face of
number?
record?
paragraph number 17 onwards, your lordship was pleased to hold what was there against the husband. Accordingly, serial number such and such is expertly allowed. Consequently, the proceedings of ACGR case number 708 of 2022 arising out of such and such case, without provision of pending before the Court of Learned Additional Chief
No,
Judicial Magistrate.
observation. Where is the observation?
Oh, my lord,
that
the observation, yes. Yes.
Paragraph 13, whereas she was assaulted by her husband only and was treated as Vidyasagar Hospital. Injury report also indicates nothing against in-laws.
Yes, your lordship. There, she kindly takes up the 161
After
statement.
careful scrutiny of the materials available, this court does not find any sufficient so argument this proceeding were to be continued. The conviction of the petitioners are bleak and remote. The securum justice proceeding are deserved to be quashed under section so.
Yes, your lordship. So,
So,
if your lordship kindly tallies paragraph number 13 with my annexure B once. Annexure B starts from page number 28. 28 onwards. Now, my lord kindly says, this is the WhatsApp chat between my wife and me. So she says that on 12th March, Lord, so she says that she is going to Pune. She was not at all physically present. Now, if your lordship kindly takes a paragraph
Paragraph
8,
7, you come to the paragraph 7, in the last 4 lines, again on
Yes,
8
yes,
to 2022,
Hmm.
her husband came to her parent house and further demanded such amount, and on protest she was assaulted.
yes, your lordship. Again on 8,
So all these avoidments are the cognizable offense.
but my lord, this averments, if your lordship kindly comes to paragraph number 8 once, just the next paragraph, it further appears that the complainant or opposite party number 2 filed matrimonial suit being mat suit number 494 of 2022, praying for divorce under section 13(1)(a) of the Hindu Marriage Act 1955 on 14/2/2022, and the same is pending before the learned additional district magistrate judge, 14th court, Alipur. After 6 days of filing the mat suit, she lodged a complaint against her husband and in-laws with an exaggeration. Though these allegations are not pleaded in the mat suit, rather allegations are contradicted with the allegation made in the FIR. The dates of the incidents as mentioned in the FIR do not match with the pleadings of the mat suit. No allegations were made against any of the in-laws.
That is regarding in-laws, not regarding the husband.
Yes, but my lord, the
She has
date of
restricted
occurrence, that
she
also is,
has restricted the allegation only against her husband regarding demand of dowry and physical assault.
yes,
That is sufficient. No,
my lord, that particular part is not tallied with the date,
what
the
date?
malice, my lord, the malice in the complaint, and that's not matching.
FIR and charge sheet has been filed in this case.
Charge sheet has been filed, your
So-
lordship.
So there is a specific allegation against the husband. He demanded not only once, on many occasions. Number one. Number two, he also assaulted her. A specific allegation. Now, how court can embark upon the trial?
My lord, that particular allegation is only in the FIR.
Other in-laws, there was no direct allegation, vague allegation, omnibus allegation. That's why I quashed those accused persons from this case.
I'm deeply obliged for that, your lordship.
Regarding husband, there is a specific allegation,
My lord,
and
thus,
allegations are cognizable in offense. Cognizable offense. So how husband can be exonerated?
my lord, because that
Now
particular
on
FIR,
this issue review, how review can apply?
because Milord had also correctly recorded here that the date of occurrence, Milord, she has exaggerated in his particular allegations in the FIR.
No.
So there is a patent malice in the FIR.
Specific, I have mentioned that on 8 to 2022, he went to the parents' house,
And
demanded and also assaulted. She was also treated there.
Milord, and that all those things
And
were suppressed in the FIR.
Injury report not indicated against the in-laws, but indicated against the husband. So how he can be exonerated?
Milord, that is the only point I'm coming to, because she has never stated these things in his mat suit application, in the divorce application, divorce petition.
Divorce application is different. Just
she has
I have quoted your submission that while she filed a matrimonial suit or he filed a matrimonial suit, in that case, no allegations has been averted. Only I have quoted from your submission. I cannot go through that record. I cannot enter into the matrimonial suit.
Milord, that's why
I am
those.
only concerned with the criminal revisional application, the FIR charge sheet.
Yes, your
In
lordship.
FIR and charge sheet, there is a specific allegation against the husband regarding demand of dowry as well as assault. So when there is a assault, when there is a demand of dowry, the FIR itself is a disclosure of cognizable offense. Not only that, after investigation, some materials found against the husband. So how he can be exonerated like others in-laws? Show
Milord,
me
Milord,
where is the mistake, where is the error?
because as per the judgments that I had shown before,
When review can lie?
Milord, this is a recall application.
Recall
Application.
Recall.
Milord,
How recall a judgment pass? How a judgment can be recalled?
Milord,
Provision.
My lord, I am asking for recall on some particular factual
What
aspects.
you can please say
My lord, my only submission before your lordship is,
can be recalled.
my lord, recalled and modified to such extent that the husband should. My lord has got the power under section 482 CRPC.
482.
My lord, to
Or
modify
regarding
it.
482 apply.
My lord, to modify it to such extent only so that the husband can be exonerated too.
You have to clarify yourself what is recalling and what is review. When the judgment pass, how court can recall a judgment?
But I'll satisfy
At
that.
best, review can be done if there is a error on the face of record or something has been left out by the judge
My lord,
while
that-
considering the judgment.
my lord, those points have been stated in my application. My lord, I will satisfy your lordship. I'll come back.
Okay. What satisfaction is that?
Five, my lord, I am for the petitioner. তুমি five এ? হ্যাঁ, কি আছে?
Asif.
No, no.
Asif Muhammad, alias Asif Muhammad. Yes. I heard this matter earlier.
My lord, just time to refresh this matter, my lord. I am submitting before your lordship. Kindly, this person has been, my lord, made an accused in a case of, my lord, the alleged transaction of NDPS, my lord. My lord,
Oh, yes,
kindly
please,
come to the FIR first, my lord. Then, my lord, I will not take much time in the, my lord, the fact. Thereafter, I will come. Now, the point is that, my lord, one consignment was, my lord, apprehended by the officer in charge of Malda police station, alleging that, my lord, that consignment, my lord, was, my lord, containing, my lord, certain articles which are, my lord, the narcotics contraband.
You are
My lord, Muhammad Asif.
Muhammad Asif.
Now, my lord, question is that the person who were apprehended at the time of alleged search and seizure, my lord, one of the person, my lord, took my name. On the basis of the same, my lord, the FIR has been started. In the FIR, my lord, I have been described as an accused number 2. My lord, got it? My lord, I stand correct, my lord, not 2. As the accused number 3. Accused number 2 is Arif. I am the Asif. I am the person of
Two persons were apprehended.
Yes.
One is Masroor,
Masroom, correct?
Masroor, and one is Muhammad
Muhammad
Asif.
Arif, perhaps it will be Arif.
Oh, Muhammad Arif. Yes.
Arif.
Muhammad Arif. Okay.
Both of the persons with the, my lord, the vehicle, they were, my lord, apprehended. From one of them, my lord, made a statement.
Confessional statement was recorded and your name has been transferred.
Transferred in the very instant in the FIR, and my name transferred as the accused number 3 in the FIR. My lord,
So Masroor was a driver
driver on cleaner,
and one Muhammad Arif was a
the
cleaner.
helper, or my lord, the
Helper.
helper, whatever may be. Now, my lord, question is that, my lord, thereafter, police started investigation to that case. FIR was registered under section 21C as per the alleged recovery. 29 is the so far, my lord, the conspiracy part is concerned. My lord, I have approached before this honorable court for anticipatory bail. My lord, kindly come to page 13. Page 13 is the, my lord, my order passed by this honorable court granting me anticipatory bail. Here, my lord, two things has been, my lord, argued in respect of, my lord, the phone call. My lord, this is the one of the, my lord, the vital evidence in the prosecution's hand. Learned senior counsel advocate for the state submit that petitioner is the man of Uttar Pradesh, admitted fact that I am a man of Uttar Pradesh. That is not an offense if you are a man of Uttar Pradesh or Gujarat. Statement of the co-accused implicate the petitioner. Further inquiry was made. It was found petitioner was using a fake SIM card to communicate with the accused person. Prayer has been made to collect the consumer number, FSC suggestion SIM card. Then, my lord, the consideration part, we have considered the material on record. Conspiracy of the petitioner to the co-accused person is preliminary based on the statement of the co-accused before a police officer, which are inadmissible in the evidence. Further report submitted also does not show the petitioner is the owner of the SIM card or mobile phone through which the telephonic conversation was made. Therefore, my lord, the source of information or the, my lord, the what I say, the bridge or, my lord, the connection between the accused and this present petitioner, that has been, my lord, demolished. In view of the sense, my lord, the 37th, my lord, covered, and, my lord, my anticipatory bail was granted. Then, my lord, the charge sheet file. After filing the charge sheet, we have going through the charge sheet, my lord, I find that none of the evidence against the present petitioner except, my lord, the co-accused statement. Neither there was any telephonic conversation by and between the parties who were, my lord, apprehended from the spot prior to or after that. Neither, my lord, there was a money trail with those accused person. Neither, my lord, any independent evidence or independent witness spoken about me, my lord. Only one statement of the co-accused. This is, my lord, against me. After filing of charge sheet, supplementary charge sheet was filed. Even in the supplementary charge sheet, my lord, there was no whisper in respect of my role in the alleged offense. Therefore, my lord, there is no, in absence of the other independent evidence or, my lord, any other suspicious material, my lord, a person have to face a trial. That will be, my lord, purely abuse of process of law, because this person has made this statement. I have no scope to cross-examine those
You have
persons.
been arrested. You have been arrested.
No,
You have not been
I have
arrested.
anticipatory
Bail.
anticipatory bail was granted by this honorable court, and observing all those things, my lord, that is not that on the basis of the statement. The report was called for by this court division bench. The report was before that court. There was nothing to show that my involvement in this alleged offense. Later on, my lord, the charge sheet, after going to the charge sheet and the supplementary charge sheet, my lord, the case has been developed. I can waited for the time that anything.
Definitely during investigation, case will be developed.
Yes, but nothing has been developed.
Nothing has been developed
Nothing.
against you
Nothing.
in charge sheet.
Even charge sheet, subsequently supplementary charge sheet.
Nothing against you.
Nothing. Only
accept
accept the co-accused
they will
statement.
accept the co-accused
Co-accused statement.
There is
My lord,
something-
what can be there? There can be a nexus with the person who were, my lord, apprehended. That is not the in the place of record. I am not the owner of the car. I am not the transporter. My lord, the assignment was not booked in my name. Assigned was not sent by from me or my place. Or, my lord, there may be a money trail with the other accused person. Nothing is there. Only this point, that the person who has taken my name, saying that by using that mobile number he is used to talk, even though that was inquired and it was found that the phone number is not belongs to me.
Anything else?
My lord, this is the factual aspect. My lord knows the provision of law. I will not trouble your lordship. Let my
You are relying upon the
my lord, Tufan Singh is the, my lord, the principal judgment, and 2024, my lord, one judgment was passed by this honorable Supreme Court in a case of, my lord, the Tamil Nadu, where this actual in factual consent, my lord, the expert, my lord, this order was passed and he was discharged from this case, my lord. My lord, I'll give, my lord, I just ask him to bring a hard copy, my lord. I have a soft copy. I am giving.
Copy is with me. My lordship, want to see me?
They,
My lord, before going to the judgment, my lord, kindly
Give
consider.
the reference.
my lord, just
Here the net to.
2024, my lord, 2024 SCC online, SC 3830. My lord, kindly come to paragraph number, my lord. The factual aspect is, my lord, the paragraph 2. Paragraph 2, my lord, regarding the fact, more or less the facts are same. Then, my lord,
And which is the relevant paragraph?
my lord, I am going 10. Paragraph 10, my lord, kindly come. His discharge application was turned down by the learned trial court. Against that was, my lord, paragraph 10, as is evident from the said section, the alleged offence is, my lord, got
Yes, yes.
paragraph 10. My lord, that is 27 regarding the money trail.
This is regarding consumption of narcotic drugs.
Yes.
Only small quantity.
That is, my lord. Here, my lord, we are, my lord, regarding the not the quantity, the principle is that, my lord, that on the basis of the statement, the accused number 13, based on the confession statement of a co-accused person number 1, that is currently absence of any other material on record to contain the appellant with the crime, the confessional statement of the co-accused by itself cannot be reason to for his implication in the crime in view has been ratified by the said law laid down in such and such case, my lord, where the co-accused confessional statement regarding the same. Then, my lord, paragraph 11 and paragraph 12 is, my lord, the ultimate, my lord, the as noted herein before, the sole material available against the appellant is the confessional statement. In my case, my lord, respectfully subject to lordship kind sanction, only the confessional statement of a co-accused, why is the co-accused number 1, which is undoubtedly cannot be translated into admissible evidence at the stage of a trial against the appellant. When that can be the position, how can they say the prima facie case is made out against the appellant in the court before the court of trial? My case is, my lord, absolutely on the premise of this. তার সিটটা কোথায় লাগলো?
Yes, during investigation, what
My lord,
evidence transpired against
on
him?
earlier occasion, lordship, when learned senior counsel Mr. Mukherjee is arguing in this case, lordship was pleased to direct me to take some instruction that is there any material, other material against this petitioner, other than the confessional statement of the accused person. My lord, in this report, I have obtained the report, the regard, my lord, that as per statements of the other co-accused persons as well as police personnel of Red Team, Asif Mohammed Vicky was also involved in this crime. The co-accused demanded that entire siege fensible was only the co-accused statement. My lord, nothing.
In CD,
Case diary is with me, my lord. In the case diary, my lord, I couldn't find that other than because that, my lord, ultimately this honorable court already been observed in this case that the CPR is also not matched. My lord, so in the anticipatory bail application, my lord.
My lord, may I give the hard copy, my lord?
you have hard copy.
My lord, the only one thing I have to object, my lord, that is the quantity. That is 20,000 bottle of fensidyl has been recovered.
No, any document has been seized.
Nothing, my lord, nothing, because he is a person from UP, my lord. What happened? I am
Maybe UP, but in CD, while intercepted the vehicle, nothing, no paper was seized.
not against this person, my lord. Not against this person. This is enter case diary, my lord. I have
Okay, give the case.
And my lord, another thing, my lord, what the investigation officer has told me, my lord, that they have obtained some WhatsApp chat, WhatsApp call, but they did not. Lordship is well aware of the fact that CDR cannot be produced from the WhatsApp call. If they will make call from through internet, my lord, this is the problem over here. And this is the case that you will consider.
Subsequently, my lord, other accused person also made the accused. Other person has been made an accused. 7 person has been, my lord, the charge sheeted, supplementary charge sheeted. But my lord, after going through the, my lord, all document, my lord, subject to lordship kind sanction, I have found nothing. Only the statement of the co-accused.
My lord, this is the memo also, Lordship kindly consider.
And this is not a case, but I have fled away. I was all along before the court.
Okay.
Because this is
And the
inadmissible in nature.
other evidence, then
And co-accused statement is inadmissible.
My lord,
my lord.
I have
prima facie inadmissible.
I-
But
I-
if there is any connected evidence collected during the investigation, then he
That will-
cannot be exonerated. He must face the trial. This is the
this is the
legal proposition.
proposition.
My lord.
But my lord, so far the present case is concerned, only they tried to, my lord, the prosecution what
I
happened.
have heard
they-
you. I will go through the entire case
Lordship will
record.
explain.
Yes.
I will find out if there any connected evidence.
My
Then your result will be negative.
Yes, my lord.
Otherwise, as per the judgment of Tufan Singh as well as 2024 case, more or less similar facts are there.
Grateful, my lord.
Let us see
And,
whether
and one thing, my lord, the contraband was recovered from Arif. I am Asif. This name is, my lord.
no, I have understood now. I have understood now. You are not there. You are the resident of UP.
Uttar Pradesh.
Uttar Pradesh. Their contention is that the whole contraband goods belongs to
He is
Me.
he is
the present
source. He is
petitioner.
the source.
Yes.
He is the source.
But to that extent, nothing in.
So to prove that at least some documents is
Yes.
required, some telephonic conversation or call details required.
My lord, bank transaction.
The money trail must
Nothing.
be there. Hmm.
Nothing. Neither money trail nor call. So far the charge sheet.
So let us see. I will go through the entire because CD is not small. CD is very big.
I called up them several times, my lord. Just give me some point at least. My lord. Negative.
Let us see. Next.
Grateful, my lord. Grateful.
This was also heard last occasion to some extent. Please refresh.
CBI.
CBI, please refresh.
After my land CBI finish, I will.
What is the case? Please
Lord,
refresh.
6 and 7 both be taken up together.
charges have been filed against me
Uh,
by the CBI for having done something when I was not posted at the
so you
place of
put in FIR name.
Lordship. And also that the incident of 2009, they filed a charge sheet in 2013. I joined in 2010.
Yes, yes, now I remember.
Your Lordship, I told,
Period of
my lord, my lord.
allegation,
My lord.
you were not there, subsequently you joined. Yes, I remember this case.
Lord, they'll make the submissions if need be. I'll give my reply next time.
Yes,
I'm filling it.
he has only made a payment. You have only made a payment.
No, I have not made the payment. I'm not the
You
disbursement.
also not paid the
No.
payment. Just you have joined. And what
I
was the
have checked.
rule?
I have checked the papers that were given to me, which goes to other authorities above me.
For
Payment,
sanctioning.
the payment is decided by them, not me.
The payment was made after your joining or prior to your joining?
Prior to my joining,
Prior to your joining, payment already been made.
some of the payments, say about 85% payments were made already. That is there in their charge sheet. If your lordship kindly comes to
So,
plot 140.
15% or 20% made as per your recommendation.
No, my lord. As per my checking of records and submitting it before my superiors, because
So why you have not checked at that point of
no,
time?
my role is just this. I am not concerned with the payment and the tender business at all. I am divisional engineer signals. I have to
only
see
concerned about the payment.
signals.
The remaining portion of payment.
No,
should
I'm
be
not
made.
concerned. I was not concerned with that also. I was not
What is your post?
divisional
What was
engineer,
your post?
senior engineer signals, my lord.
Senior
Engineer signals.
Divisional Signal and Telecommunication Engineer, DSTE, Southeastern Railway.
STE.
TE. Lordship, page 56 in the chart sheet, Lordship will find. Let my learned senior finish.
Okay. So what is your contention? In both the cases, similar facts and circumstances. Yes.
Lord, may I have your lordship leave to leave? I'll give my reply if my learned friend takes up.
Lordship, initially case was registered under the.
You have filed your opposition.
Yes, Lordship. Lordship, prior to that, I am just taking some points. Lordship. Page 42, Lordship will see.
42 of?
42 of the petition. This is first CRR 2422 of 2021.
Yes, 42. Yes, 42.
Lordship, kindly mark some dates, Lordship. Case was registered under section 420, 468, 471, 13, 1D and 32 of the Prevention of Corruption Act. The period is during the year 2009. Against some unknown persons, petitioner's names transpired. Thereafter, in the charge sheet,
Petitioner name was not in the FIR.
not in the FIR. Subsequently, his name transpired in the charge sheet. Lordship, case is based on the documentary evidence. Petitioner names transpired later on when the documents reflected the role of the petitioner. Thereafter, page 55, Lordship will come. This is the charge sheet. Page 56 is the name of the petitioner. Lordship, column 2, Lordship has found.
55 you are showing?
Page 55.
Charge sheet.
Charge sheet. Page 56, petitioner is Debashish Ghosh. He is the occupation D, then DSTE. That means, Lordship, Divisional Signal and Telecommunication Engineer, Southeastern Railway. Kindly note it. Now, Assistant District Signal and Telecommunication Engineer.
Nowhere it is mentioned that when he joined in the post until when he was there.
Lordship, it has been mentioned.
Where?
Lordship, it has been mentioned. Joining, petitioner joined. Paragraph 13, Lordship will see in his petition itself.
No, that I see.
Page 13, paragraph 16.
Page number?
13, paragraph 16. That your petitioner joined.
13.
Yes, Lordship, page 13.
No, in your complaint. I'm asking about in your complaint.
No. Lordship, in the complaint, it was not mentioned as because he was not.
You are just now say this case is based on document.
Yes, Lordship.
So documentary evidence
Lordship,
is
from the
there.
document we will prove it.
So
From the
where is
document
that? Where is the role you have?
Yes, Lordship. Lordship, prior
You
to
have
that,
to
Lordship,
indicate his role.
Lordship, prior to that, Lordship kindly come to the affidavit in opposition filed by the CBI.
Yes.
Page 3, paragraph 5.
Page 3, paragraph 5.
Lordship has got it.
Yes.
That investigation revealed that petitioner in his official capacity during the period of 2010 to 2011 was responsible for conducting test check of various work, laying of power cables, data cables, and concrete cutting of platform from the installation and commencing ETBS Chengil, Bishpur, Kulgachia railway station under Howrah Kharagpur Digha section, Howrah railway station, and Southeastern Railway, and measurement was recorded in the MB. MB means measurement book, where false and inflated. This inflated measure was certified to be corrected by the petitioner and countersigned by such and such, who claims bill against this inflated measurements by measurement book. After finding the inflated payment with less work on ground, an amount of rupees 3,65,597 was recovered by the Southeastern Rail from M.A. Astor, who was the beneficiary. As per contract agreement, and rupees such and such yet to be recovered from the said firm. Petitioner has certified the completion of the aforesaid work. Lordship, kindly see the role of the petition. And thereafter, Lordship, kindly come to paragraph 9.
So he is the person who certified.
Lordship, he is the person who has signed all those documents, who has on the basis of
how without completion certificate, how 80% money was paid?
Lordship, in his administrative capacity, he has signed and he has verified it to be genuine.
My question is that without completion certificate issued by any authority, how payment has been made 80% or 75%? If 80% money has been already paid, that means that was verified earlier. When he joined when only balance amount was there. How you are saying that he is the certified completion of aforesaid work? Is there any document? Can you show? Can you show?
Yes, just.
Can you show from your case diary that any document he has been signed that the work has been completed after his joining?
Lordship, kindly come to paragraph 16.5, page 65. Lordship will get the answer.
65.
Paragraph 16.5, page 65. That is a part of the charge sheet.
65.
16.5. Lordship, may I permitted to read? Investigation as part revealed further that such and such Kharagpur division Southeastern Railway initiated process of floating of open tender through a note dated such and such Kharagpur in the matter of provision of ETBI various stations under Kharagpur division. Such and such approved the proposal on 17/6/2009. GD Panigrai, Officer Superintendent, tender prepared tender notices for 7 works, including the work in question at such and such railway stations. On the basis of the cost worked out in the work schedule by the then divisional signal and telecom engineer, Sri Sanjay Chattopadhyay, Aito on, these notices were issued under the signature of Devashish Ghosh. Lordship, kindly make a note of it. On 19/6/2009. My learned friend's contention is that at that point of time he was not in position. Lordship, this is the document. This is the document. This is the point. Under his signature, it was
That's why
done.
I'm asking you, when he joined the service, when he joined the post, you are showing 19/6/2019, though he was not there at all.
Lordship, he has signed it. We have
How can
collected
I
the
sign it?
measurement book. We have the document, Lordship.
When he joined,
In the
first of all,
measurement book, we have
during
marked it.
investigation, you have to indicate first his tenure of his service. When he joined,
6/1/2010. And he's talking about 2009. I was not there to have signed.
how this can be?
Lordship, where is the document that he has joined 6/9/2010?
Service book will show. My service book will show. You have a record of that.
You have joined on
6/1/2010.
6/1/2010.
And what they are saying is relates to 2009.
That is seven months ago. How he can sign?
Lordship, he has joined prior to that. That's
Where
why he
is
has-
that? You have to show. You have to show.
Let
That
them
is
bring
the
that
first,
document. below.
first investigation. The investigation officer must collect was the service period, whether he was there or not. If someone sign on his behalf, whether he will be liable for any commission of offense,
Page 140.
he is not at all there. The first question is that whether he was available on 19/6/2019 or not.
Refresh kar do.
First,
That's why I am asking
No role.
when he joined in the service and till when he was there.
This is the reason, my lord, I had drawn your lordship's kind attention to my document at page 140, 140, where it is stated categorically by them that he cannot be hauled up for such events that have taken place prior to his joining. Means page 140, my lord. It is the railway document.
we have,
Lord, may I read that paragraph?
we have,
From the above, it may be appreciated,
This
That-
note was collected by the investigation officer.
my lord,
Lordship, that is
it's in the part of the charge sheet,
It is the part of the charge sheet you have submitted.
Yes, yes.
saying that there is
We
no
have
role,
we
no
have
role can.
collected the measurement book, it is document 5. But regarding that service table,
That no role can be attributed to me. It is that document.
Where from I will get that you have joined on
Not my service book.
6/1/2010.
My service book. No, I am
have
since
the
retired
service
from
book.
Lord. I can bring it. Lord. I am since retired, Lord.
Nowhere in the document you can show. Nowhere from the document you can show that you are joining on. You are joining on 6/1/2010.
Lord, I shall ask my client to point it out. 6/1/2010 তুমি জয়েন করেছো এটা নয় 140 নয়
Lordship, Lordship, we have the, Lordship, kindly take the other divisional application, here document is there. Page 84, annexure P3.
My lord, page 81.
Lordship, no,
81.
Page 81.
Yes, 81. Please come to 81.
Lord, confidential report
Hmm.
for officers up to selection grade 81. First. Lord, DSTE, TM, GRC up to 5/10/2010. DSTE so-and-so Kharagpur from 6/1/2010.
Lordship, it shows that petitioner was prior to that in the office, prior to that in his service, Lordship.
GRC
If
somewhere
that
else.
If he is not in service, how can he claim that medical benefit? He was absent on duty, so he was in service.
It is not my case that I am denying I was not in service. I was in garden deeds up till 5/1/2010. And from 6/1/2010, I am in Kharagpur. The events have taken place in 2009. Page 81, my lord.
You come to a page 81. DSTE oblique TM oblique GRC. GRC
Garden Reach,
means
GRC,
garden
Garden
reach. Garden reach.
Garden Reach. Where is Garden Reach? Where is Kharagpur?
up to 5/1/2010 and Kharagpur from 6/1/2010
That is my case.
to till date.
Till date means till his retirement.
So how he can be implicated in this case? He has no role to play. All payment has been made prior to joining. How he can sign the document?
Worship, kindly come to the next revisional application, page 84. Worship, you get that.
No, no, we are application number 1 now.
Both are done.
Case number?
The next one.
Yeah,
Page
page number.
84, annexure, P3, annexure, yes, P3, page 84.
Yes.
That temporary.
This
that
is a
post,
posting order.
being operated senior scale as such and such is transferred to Kharagpur for a period of 1 year from its operation. This was issued on 10/12/2009.
So
I was in
Both
Kharagpur.
is, transferred and posted as a Kharagpur and posted transfer.
10/12/2009 this letter was issued,
10/12.
and you are saying 19/6/2019 2009
9.
6 months prior.
Anyway, no, so I have to then check it out. Well, how, I mean, it can't be possible either in both ways.
Where is the notice? Please show me the notice. Have you annexed the notice?
No.
Do you have notice in your case diary? Is there any notice?
I don't think they will have that notice.
Let him check.
डेट ऑफ ज्वाइनिंग वहाँ दिखाया फर्स्ट इसमें पेज नंबर उसको मार्क करके पेज नंबर मार्क करके 81 फर्स्ट एप्लीकेशन पेज 81
So from your own document, it is so that he did not join. 84 is the transfer order, and it was passed on 10/12/2009. How he can sign notice on 19/6/2009?
That measurement book was seized. From the measurement book, it can be reflected. It was seized. It is a document file.
No, please show me the notice where he has signed. Though he was not there. You come to page number 17, 70. In second one. Date of test check in measurement book by Sri Devasis Ghosh, the then DSTE, dated 30th 30th/12/2010 and date of submission of bill 30th/12/2010. Here is the role played by him. Page number 70. Do you have any answer of this?
My lord, I have.
Amajit, have you find page number 70?
Yes, Lordship, I have.
Louis 20% final payment.
The final payment was released after measurement by the Devasis as well as Abhijit Gupta, the then SSC Telecom.
No, my lord. Only the 20% remaining.
Maybe. But at that point of time, his duty is to verify.
That is
even if earlier staff or earlier employee done
I cannot
some
take advantage
mistake
of that, but my
or
lord, here
fraud or whatever may be the allegation, he must have disclosed. And two places, Andul,
test check, my lord.
Tamluk.
Test check is not the final check.
Paragraph
Test check, my lord.
page
Test check relates only to
Check in measurement book by
test.
measurement must be there.
Not the payment. I'm not concerned with the payment. I'm only concerned with checking whether
Final
the work has
payment
been.
was made on 3rd January 2011 on the basis of his own report.
No, not on my report. No, my lord.
Final payment has been made
Lordship,
subject
may I just explain?
to satisfaction of the final
Lordship,
check.
kindly give me 2 minutes. Lord, a work is allotted. The contractor carries out the work. The work is carried out by the contractor. Payment has to be given to the contractor after the railway authorities are satisfied that he has executed the work granted to him for a particular piece of land. I am concerned only with whether the contractor had finished his work or not.
Only test.
Only test. That is the word. That is my test. I am not concerned with the payment.
So
I
that
have
work
gone-
has not been
I have
done
gone- I have-
and payment has been made. How it can be?
No, my lord. It's not that. I have gone. I have physically tested that the work so demanded of the contractor has been
According
executed.
to you, the work has been done.
Lordship.
But that is not the.
No, they are
actual
not saying the
picture.
work has not been done. It's not the CBI's case that the work has not been done. It's the CBI's case that 20% payment, 80% they've already. There's no.
Those who are liable, they will be implicated.
No,
but
there's
20%
no
payment
dispute.
was
No, there's
made.
no dispute about the 80% payment. That 20% payment on the basis of a test report. I have seen and said, yes, the work has been carried out. It is not the denial that the work was never carried out. Work had been carried out. It is not saying that the report is fake, that there was no work carried out and you have given a false report. That is not the case. It is not CBI's case, my lord. It is not the CBI's case that no work had been carried out. Had no work been carried out, then the 80% payment could not have come.
Yes, anything?
Lordship, kindly, I am clarifying. Kindly come to page 69 of the first petition, paragraph 16.4.
First one.
Lordship, paragraph is same in the chart. Investigation revealed such and such supervisor accused Abhijit Gupta, then senior secretary, took measurement and completed work, made necessary entries to the measurement book, which is countersigned by the measurement book was seized, it was document filed. Thereafter, the said representative submitted bills as per quality measurement based on the measurement book along with the relevant measurement book to the OS tender. The accused Devashish Ghosh, then such and such, who was sectionally in charge, carried out test check and entries of the measurement book and certified the measurement book measurement recorded by the accused such as. He particularly certified at many places, writing 100% checking was undergone work, 20% checking of the overground work done, measurement were found to be correct. Investigation has also revealed that accused such and such representative of the accused company as such and such relevant token of the having accepted and measurement entry respect work in question. The payment of the above work accordingly released. So payment was released. Lordship in the column, Lordship will find date was check or made on 3rd of February 2010 and final payment was released on the basis of that check 4th of August. Now Lordship kindly come to next page. Investigation revealed that on the advice of Vigilance Department of Southeastern Railway, C. B. Jadhav, then such and such, Kharagpur Division constituted a teams of officials of Signal Telecom Department, Kharagpur Division, for carrying out fresh measurements of various works pertaining to installation and commissioning of ETB various sections of such and such bigger section included. During course of such fresh measurement, it was revealed that the measurements as recorded in the measurement book were false and inflated. This inflated measurement was recorded in the measurement book by accused Abhijit Gupta, which was certified to be correct by the accused Devashish Ghosh and countersigned the such and such representative of MS such and such who claimed the bill against the inflated measurement of the measurement book.
Yes.
On the basis of that, money was recovered.
My lord, I should drop your lordship.
Sir, now, Lordship, kindly come to page 16.18, paragraph 16.18 of the chart sheet, page 72, paragraph 16.18.
Yes.
The completion of the part of the conspiracy. Investigation further revealed that after finding the above mentioned inflated payment with less work on the ground, an amount of rupees 3,65,597 was recovered by the Southeastern Railway from the such and such. He is the co-accused. He is A4 in the charge sheet at work by contract agreement number such and such in pursuance of para 51(2) of the general conditions of contract volume 1, which deals with the post payment audit. See, Devashish Ghosh has certified the completion of the aforesaid. The aforesaid amount has been recovered from the security deposit and the pending bills of the aforesaid accused firm. Thus, investigation established wrongful loss to the tune of 3,91,835 on account of fictitious inflated entries of measurement made in the measurement book by accused such as and fictitious certification of the aforesaid inflated measurement by the petitioner Devashish Ghosh for work for which final bills were processed after completion of work and payment was made. It would be pertinent to mention that an amount of such and such was already been recovered from the pending bills of Esther. The rupees Atho is still to be recovered from the said accounts.
So according to that document, lot 26,310 rupees is to be recovered. 238 rupees. According to their document.
Thereafter, Lordship, kindly come to paragraph 16.21. How, Lordship, may I read it aloud? However, the investigation has substantiated that there is a definite and deliberate abuse of official position by Abhijit Gupta and Devashish Ghosh, who were supervising the works in question on ground in their recording of inflated measurements in measurement book and certifying the same as the investigation by CBI and measurement by vigilance wing of the railways has clearly brought out the differences the measurement recorded due to which the Southeastern Railway suffered a wrongful loss to 3,91,835. Further, these false measurements were countersigned by the other.
The sanction has been obtained.
against petitioner.
Yes, yes.
No.
That I have to check it with the sanction. But next date is fixed for framing of charge because of the pendency of this application.
How framing of charge will be done without without sanction? You see 16.22
Yes.
sanction of the prosecution under
Yeah,
section
that-
so and so is still awaited.
They have not yet submitted it to the trial court. Lord, I draw your lordship kind attention, Lord, to
No,
page
I
7.
understood your point.
Lord, page 70. No, Lord, the comparative table that he has just read out. Lord, in page 70, 69. Lord, in page 70 of my application, second application. Lord, kindly see, Lord. 30/12/2010. And final release of payment is 3/1/11 by Devashish Ghosh. Then 29/12/2010, 301/11. This table. And he has just now read, my lord, my first application, page 16. Lordship, kindly note it, my lord.
Data are different.
Dates are also different. 3/2/2010. They are not yet clear what they are wanting from the court. You say it's 30/12. Then you say no, it's
No,
three-
that is the another area, Chengal, Birsipur, and these two are Andol
Charge
and
sheet-
Kamluk.
charge
These are
sheet-
three
charge sheet-
areas.
charge sheet is interconnected. That is
These
why
are connected, maybe,
Lordship.
but this case is totally different area, and these two case from Andul and Tamluk. Okay, you can whether sanction, but
So
sanction.
I will inquire from the prosecutor. And more so, lordship case is based on the documentary evidence. It cannot be proved here. It has to be go in the trial. And whatever the allegation, everything has been stated in our affidavit in opposition. That was uncontroverted. They have not, they prefer not to file any affidavit in reply to that.
No,
Kindly note
no,
of
we
it.
have prepared.
At this stage, it cannot be done.
No,
It-
court had asked me, when the back.
I am denying, lordship. I am disputing this
तो
at
वहाँ के
this stage
service
when
करे
the
थे।
hearing was taken place.
नहीं,
At this stage,
नहीं।
affidavit in inquiry cannot be considered.
CAV. Affidavit. Evidence.
The last payment is of 28,000 only.
Payment was made. That's why it
28,000.
was recovered.
Then 1 rupees is the
And he is.
No, the allegation against me for 3 crores and then 88 lakhs.
Being an official.
That is the trial issue.
He's utilizing the money of the government.
Next.
In their reply, opposition, they have not challenged 140 that I have asked.
Old matter. Other matter release. Only old matter will be taken up.
I am paying for the petition.
Old matter.
I শুরু করি. Let it be treated as hard in part. My lord will hear it after my lord comes back.
Yes.
হয় এই তো অরুণদা আছে তো অরুণদা আছে না Huh? This is for quashing of a proceeding under section 3A of the RPUP Act. My lord, the petitioner before your lordship has been arraigned as an accused purportedly on the allegation that he is the owner of a firm where allegedly some railway articles were recovered. My lord, the story goes like this, that on a secret information, the railway personnel were keeping an ambush at that time in the Bardwan railway yard. They caught hold of a particular person called Firoj. Firoj had a railway with him in his possession in a jute bag. He could not account for its possession. Firoj was taken to the RPF post, where Firoj made a particular statement that if you take me to a particular area, I will show you the place where I generally dispose of the stolen articles, but you will have to go very fast, because as soon as the goods are received in that establishment, it is melted. They have a smelter there. It's, my lord, the particular establishment where the petitioner is said to be the owner. Petitioner is particularly a director. I will come to that vicarious liability, because
Director.
he is a director. He was admittedly not present. He is a resident of Salt Lake.
But you have not indicated anything about he is the director. Paragraph?
Yes. Malar will get that from the documents or the applications filed by the railway authorities only, that it's now a public limited company. At a particular that point of time, it was a private limited company. Malada, they hold raid. My lord, they purportedly could not, my lord, RPUP Act postulates that if you are entering into a particular area or some establishment, building, you will have to obtain a
Prior permission from
prior warrant from the magistrate.
police station.
Magistrate.
This is the provision.
Lordship. I will come back. I'm saying, my lord, if your lordship hears this matter today only and disposes it of today, my family members will get angry. Your lordship will hear me at least for 2-3 days. My lord, they have to get that. They say that we could not do it because Firoj is saying it will be melted very well, so we could not. We asked for police help. Police help was not provided. So we entered the premises, we found certain railway articles there. Very good.
In the original form or melted form?
No. They say, now your lordship will kindly come. They say we seized it. We couldn't take it away from the factory premises because it was fixed.
It was fixed.
Very well. Then we give it in Jimma. Jimma of that manager of that factory only. Very well. I will take your lordships to a subsequent application made by the railway authorities, where the railway authorities claim that those railways are used as for operating cranes inside the factory premises. It was fixed.
So they were earlier utilized that area for the purpose of
moving cranes inside the factory premises. Now, thereafter, your lordship will find another story. After the raid was conducted in my premises, purportedly, Firoz said, I have another premises in this vicinity only, where also you will get similar type of articles. The police raids, the RPF personnel goes to that premises. Allegedly, at that point of time, the RPF personnel are apprehended or say, my lord, sort of taken into
recovered some
custody by those 1,000 people, in spite of repeated requests being made or frantic calls being made to the police. No help comes. Thereafter, there were conversation between the ministries of the railway and the West Bengal government. At that point of time, the left front was there. Then they were released. Then they come back to the RPF post. Then they lodged the complaint. My lord, so the incident of getting a secret information that a particular person will be found in possession of a railway property and the first information sheet being lodged on return took about 24 hours. Now, my lord, the first thing. RPF personnel at 8:45 on 2nd of July 2010 goes to the Bardwan police station. Asks for police assistance for inquiry in connection with that altogether different RPF post case. Police accompanies them. Police accompanies them directly to the establishment of the petitioner before your lordship.
where that is
Bardwan, but no story of Firoz. As per the police, till the police was there at the factory premises, no railway property was recovered. Police, as per the police, they reached my premises at around 10:15. If the police and the RPF personnel were at my premises at 10:15 in the night, then arrest of Firoz at 10:45 is totally a preposterous story. My lord, from my personal knowledge is telling your lordship, the Bardwan railway yard and the RPF post, walking distance, it will be 5 minutes. RPF posts are inside the railway yard only, your lordship knows. Maybe Asansol has 2 RPF yards, RPF posts, but Asansol has a huge railway yard. It enters into another. In fact, if your lordship must be knowing that area after crossing Asansol, it is continuing it's the same police. After Durgapur, your lordship, there is no actually demarcation line. And one town to another, it's a continuously. The first entry in the RPF post takes place at 12 o'clock in the night. Then, as per them, they go to my establishment.
again
in the morning. They are not saying at the first, or as per the railways, they never visited my premises on the night of 2nd.
okay
They first go to my premises on
the morning
as per them, they go in the night, but the first seizure takes place at 6 o'clock in the morning. One seizure, I don't know why 2 seizures. They claim one seizure at first at 6 o'clock, another takes place at 10:30 to something in the. Now, I tried to demonstrate before the court, before the trial court also, before the court of the magistrate. Look, these are 3 of my employees were arrested. This has been legitimately obtained. These are the challans, these are the carbon copies. I have annexed those documents. I will not trouble as of date with those documents. Kindly verify it. I will show from your lordship's order reluctance on the part of the railway authorities or the RPF post to take those even, in spite of the order of the magistrate. When forced by the learned magistrate, they take those, and purportedly Faisal expert opinions report. Two things I will draw to from the expert opinions report and this result list. Your Lordship will find that the articles which were seized and the articles which are placed before the expert are different. And different.
Not match.
And expert is of the opinion as if rails are only prepared for the Indian Railways. Rails have no other use. Privately also it is not used. My lord, in my childhood days, I have seen railways being fixed in the roof to hold the ceiling. It was not, at that point of time, there was no, this dhalai and all that was not there. Thick walls, thereafter the railway and over that. Apart from that, initially SAIL only used to make railways for the Indian Railways. Now Jindal still makes it. There are various parties have come to it. I am telling you just like this. Your Lordship goes to any XYZ factory premises for internal movement of the goods, raw materials. There are movable cranes. Those movable cranes moves on over a tracks. Whether it is DSP or any thermal plant or any steel plant, private, government, any big industry, whether there has to be a huge movement of goods.
But that should be with crane.
The rails are brought. Admittedly, when the first impression is being thrown to the court of the learned magistrate, it is said railway materials have been recovered. They are not saying it is crane. Thereafter, they take out an application. We have come to learn that Bajrang Agarwal is the owner of the
Factory.
We had taken out an application saying, look, vicarious liability is not. In penal offences, why there cannot be any vicarious liability. Whereas 3A says, it starts with the whoever is found in possession of any railway articles believed to be stolen can be prosecuted.
So even if company is there, then what would be the
My lord. Now, what Firoz says? Firoz says, I go to the factory. The factory people get it and get it furnished, melted in the furnace. How does, there is not a single iota of evidence, it was not done by my employees. There is no 120B in 3A of the RPUP Act.
Possession must be from the accused.
Stricto sensu possession from the particular accused person.
Even if the possession
My lord,
factory, then who will be the liable?
My lord, I'll come to these NDPS cases. NDPS cases.
My question is,
yes. My lord, they have to lead
factory or manufacturing.
They have to lead certain evidence, some evidence that this particular person was in charge of the running of the factory.
At that point of time.
At his command, these persons have done it. Some semblance of material, some evidence, some statement of my employee only. This was done at my instance.
Then if company made an accused.
No.
No company, no unit.
No.
Any accused.
No.
So how vicarious liability will be?
I'm not going on that. I'll be telling your lordship, if your lordship sees the timeline from 8:45 to 8:45 on the next day. No, next date. Afternoon.
Okay.
Day after reading my
8 hours. More than
24 hours.
24 hours.
If you're 24 hours, your lordship will see. My lord, truth doesn't require any lie. But to hide a lie, 100 lies are spoken. Your lordship will find from stage to stage they have tried to develop their case. Because at 10, as per the police, at 10:15, they were in my premises. And till the morning when they had left, no railway material could be seized.
And in the morning and the fine morning, some
Yes.
articles were seized.
There are two scissor lists, one of the crane and another scissor list of some railway articles.
Crane belongs to whom?
Me, I have given the documents, which they are reluctant to consider even. Now, thereafter, another application taken out, but by this time, the High Court had been moved and an order of stay was passed. Another application was taken out. Now, look, Mr. X is the managing director. I will come from that. I will show to your lordships. They knew that it's a company.
Subsequently, they came to know.
My lord, NDPS cases. Initial stage, it is said, I have financed the transaction. Very well. But as from the co-accused statement, after the submission of the
Charge sheet.
How you implicate me?
There should be some connection.
Some material.
Some material, some connection, connecting evidence.
একদিনে শেষ করো না, দাঁড়াও।
Lord, at the stage of Milord inquiry, FIR and inquiry, charge sheet has not been filed.
Not filed.
No, just Milord, at that stage, Milord, this proceeding was stalled.
Okay.
It is the real. My learned friend.
You have not filed any application for vacating.
Yes,
or
vacating
any-
application.
Yes, vacating is there.
Yes,
Vacating they have filed. That was treated as opposition, and we have given a reply.
You have not asked for any submission of charge sheet.
No.
Permission from this court to file
Because
charge
Milord, the
sheet.
application for vacating interim order was there at the earlier point of
Charge
time.
sheet has been completed.
No, Milord, that cannot be, Milord, because in view of the order, in terms of in
Why
view of the
you
order
have
passed by
not
this court,
seek any permission from this court to file charge
but
sheet?
at that material point of view, I
That
was
can
not
be
there.
added-
I have
added
came at the latter
subsequently in
stage.
this
The moment I
application.
have been brief, Milord, changed brief, Milord, after so many years, then I started.
15
We have
years.
started rolling the stones,
15
Milord.
years passed.
We have started the rolling.
What remains now?
The moment
What they will
Yes.
find in after 16 years?
After 15 years, what you will recover?
Milord,
What you will
we will
investigate?
satisfy, Milord, we will satisfy at the threshold what are the basic materials on the basis of which there is every ground to proceed against the accused persons.
I will hear you. I will hear you. Today, I think
Only-
time is over.
Only one page, page 70,
70.
lordship.
17 or 70?
70.
Yes.
He has an iron cast case. It deals with iron. It's an expert opinion report. My lord says, as per scissor list. Has my lord got it?
One no wagon wheel.
And what was produced before him? As per nomenclature,
One no hand.
one number hand wheel. I'm not taking your lordships to the other expert opinion. Your lordship, if I compare it with the other opinions, it will be
I will see.
lordship. I was praying if your lordship can it is a hardened part and fixes it after your lordship's return on some day. For us.
Can it be taken up after 13th, Milord? Any day after 13th, Milord. Item 97. Not personal difficulty, Milord. Next week, Milord.
Whenever I will take up.
Milord, after 13th, item 97.
97, whenever call,
Milord, someone will be there, Milord.
Milord,
If you
before
oblige.
Milord, before rising, Milord, one thing, Milord. In one matter, Milord, two matters were heard together by your lordship, Milord, company matters.
Today.
Yes. Then, Milord, I was given, Milord, we are given the chance, Milord. I did not have the occasion to, Milord, make my argument. Mr. Anirban Mitra make an argument in so far another matter is concerned, which is
You file your written notes.
Milord, due to some my personal difficulties filing of nomination papers and all these things, and scrutiny was going on even till yesterday, Milord. So, my lord, kindly, my lord, extend me 4 days time, my lord. In the next week, I'll file it, my lord.
Which one?
My lord, that matter, my lord, so far, Bishal Sharma.
That you have filed today.
My lord,
Anirban
only
has filed.
one, my lord, argument. He has filed, Odinbar, Mr. Mitra has
In
filed.
this way
I would,
cannot
my lord, I will supplement, my lord. My lord,
How
no,
I
no, my
can
lord. I will supplement only those, my lord, points, other
have
points, my lord.
not required.
Other points, my lord, because
I
I was not given the chance to make my argument, my lord. I on the last occasion, my
how
lord.
many chance I will give you?
No, no, my lord.
I
Only,
last
my lord.
occasion I asked
Only, my lord. You
my
no,
reports of
I Peruzo, that's my
file.
personal difficulty, my lord.
I
Only, my lord.
kept pending for
Only, my lord. 3 days time, my lord. By
I
13th, I will.
deliver this judgment in another matter. You go through that judgment also, you will find the
No, my
result.
lord, let me, my lord, some supplement, some, my lord, 4-5 points, my lord. My
And
lord, my lord, because I
I
could
have given you opportunity to file your return. It's no
no, my lord,
argument. If
because
you
of my certain supervening incident, I could
file within
by
Wednesday, you file
by
on the
Thursday, my lord. Next
I'm
Thursday.
fixing a date. If
By
you
next Thursday, my lord.
file.
This is my one, my lord. By the second Thursday, my lord. Next, my lord.
Cannot
No, my lord. Not more
pending.
time, my
Now
lord.
you
By
don't
next Thursday, I will file it, my lord.
you know judgment cannot be kept pending
No, no, my
for
lord. Not me, lord. My lord.
long.
By next Thursday, I will file it, my lord. My lord.